Hello and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today I'm delighted to be joined by a new guest to our podcast, Nathan Kotkamp, a partner in Williams Mullins Healthcare section. Welcome to the Benefits Companion, Nathan.
Thanks. Great to be here.
So this podcast is one of a series we're doing this year in 2026 on those lingering to-do items, the ones that you know that you need to tackle, but you haven't quite gotten to yet. And our goal is to give you some practical, actionable steps that employers can take to take care of these things and knock them off your list. And today's to-do is making sure that your company, and specifically your company's group health plan, is compliant with HIPAA. HIPAA means several things to group health plans. It includes non-discrimination requirements that prohibits group health plans from discriminating against employees due to health factors as to eligibility or the benefits available under the plan. It was enacted way before the ACA and included pre-existing condition exclusion requirements that we had to follow before the Affordable Care Act completely outlawed pre-existing condition exclusions. And HIPAA also includes protections for sensitive health information, protected health information, personally identifiable health information for employees. So that's why I asked Nathan to join us on the podcast. Nathan has a lot of experience helping doctors and healthcare practices and health systems comply with the HIPAA health information privacy rules that apply to healthcare providers. I'm sure if you've been to a doctor's office, you get the stack of documents that you have to fill out, and one of them is a HIPAA health information privacy practices notice that I'm sure everyone reads every single word of that notice, and we sign them. And we sign that we understand that notice. Well, that's part of the healthcare practices compliance with HIPAA. And so these rules, however, do have importance for employers. So Nathan, can you help us understand why an employer that is not in the healthcare field has to be concerned about the HIPAA privacy?
Sure. So let's say you're a widget manufacturer, but you're a big enough widget manufacturer that you've got a health plan and a health group and benefits group that it's not a separate entity, but it administers the plan, administers the healthcare plan. That group it sits in this sort of legal fiction world under HIPAA as a covered entity. And most employers these days outsource the administration of their plan. So they're not having to really get into the weeds of HIPAA, but they still need to pay attention to it. So just because you're the widget manufacturer doesn't mean you can ignore HIPAA altogether.
Right. If you have particularly a self-insured group health plan, you're in the crosshairs of HIPAA. HIPAA treats you the same as a doctor for HIPAA compliance. And I always feel when I'm advising clients, I feel like, don't shoot the messenger. I know this may not make sense to you, but your group health plan in the eyes of the law is an entity. It's a covered entity under HIPAA.
That's
and
right.
Your group health plan has to comply. And then, so who has to comply with that would be the people who administer the plan, folks in HR in the benefits department that handle the PHI that the employer receives. But you're right. Most self-insured plans are outsourced to a third-party administrator. So Anthem or Cigna, United Healthcare, or one of these entities is doing the day-to-day management of the plan. But you still can have, PHI. Can you think of some examples of where an employer that says, well, I don't really have any information, where they may have information that they don't realize is subject to HIPAA?
Well, I can think of the opposite. You probably are a better authority on what the lurking actual HIPAA stuff is, but let me talk about the flip side, and that is the fact that HIPAA is oftentimes perceived to be broader than it actually is. And so there's this tendency to consider every bit of health information to be covered by HIPAA. So what I can talk to specifically is the types of things that are healthcare related that aren't covered by HIPAA. So for example, ADA accommodation requests, they inherently involve some sort of health issue, a disability, but those fall on the operations side of the organization. They're not related to the health plan itself. So that's one category of information that is health related, but it's not PHI. The same is true for FMLA leave requests, Life insurance is not covered by HIPAA. Disability insurance is not covered by HIPAA. Drug test information. So there's all sorts of things that it's best to be extra cautious about it because it's sensitive information, but it isn't necessarily PHI. Now, the flip side of that is where you've got a benefits plan and it's self-administered, there is all sorts of information that might be available to the employer.
Right.
And so if you've got somebody who makes an ADA request, you can't go into the health plan and say, oh, does this person actually have the disability that they are asserting that they have? That's off limits. So that's at least one example where I know that there's sort of a crossover.
Yeah, I can think of, so maybe somebody has a workers' comp claim
Right.
for back problems, and it may be tempting to go, well, have they? This isn't new. I think they've been having claims under the health plan for back problems for a couple of
Right.
years. You
Right.
can't do it. That it's protected information.
Yeah. Yeah.
And an example I often use is, an employee breaks his leg and he calls to a supervisor and says, I can't, I'm not going to be in for a couple of weeks. I break my leg. Is that PHI? Is that subject to HIPAA?
I would
No,
say no.
right. It's not.
Yeah.
But the employee goes to CVS and has trouble getting the pain medicine prescription filled and calls HR and says, can you help me? The plan isn't covering my prescription. Now I broke my
Now
leg,
it's PHI.
right? It's the same kind of the same circumstance, but it's the context of what hat is the employer wearing
Yeah,
that
exactly.
that they have to be thinking about.
Yeah.
Yeah, some examples of PHI that an employer may have are those types of employee questions. So you get emails asking about claims or assistance with claims. Some employers with self-insured plans, the final level of appeals and review is a committee with the employer. So the TPA handles just the first level claims denials and approvals, and then they can appeal, and it goes to a committee at the employer. Not everybody, but some employers do that to have control over their plan. Well, when they get that record, all of that information is HIPAA, subject to HIPAA, because this is clearly a group health plan claim. And this game, I'm kind of going off track a little bit, but then when clients call me and want me to help them, you only disclose the minimum information necessary for the purpose of the disclosure. So when you reach out to your lawyer or some other advisor about a claim, you can't send them the whole file. In fact, I shouldn't even know the name of the employee. I don't need to know the name of an employee to help you with the ERISA aspects. So that's examples of how an employer may have PHI. So now that we've established that no matter what, even if you have a third party administrator, you probably have PHI. What are the things that an employer has to worry about for HIPAA compliance?
Well, at a minimum, policies and procedures. And these can take a lot of different sizes and shapes and appearances. There's plenty of vendors out there that will offer up HIPAA policies and procedures for really darn cheap. My experience has been that you get what you pay for. The one sort of obvious caution that I would give to anybody who has policies and procedures is to be sure they've actually read them. If you've got a set of policies and procedures that have the like bracket, fill in the entity, close bracket in 1,500 places in your policy, you don't have a policy. I mean, that's just the
Right.
reality is you haven't done the work. So I think it's just a matter of being sure that you actually do have policies, that you are aware of where your PHI is going, and that will implicate whether or not you have business associate agreements in place. And then at the same time, recognizing that when you're the covered entity, you don't get to hand off everything, even if you've got a third-party administrator for your plan. So, for example, if there is a data breach with your TPA, at the end of the day, the plan, which is the covered entity, is responsible for making sure that those letters go out correctly. So you can outsource that, you can push it down to your business associate, but you got to remember at the end of the day, the plan is still responsible. And so that's one of those places where I think there can be some confusion about the breadth of outsourcing can be very, very broad, but you still have to have, the buck stops here kind of thing. You can't ever forget that.
Yeah, and that's a really good point about the buck stopping with the employer. So, with breaches of unsecured protected health information, electronic protected information that's improperly disclosed, there have been situations where the TPA has sent records to the wrong employer, for example. And I've seen situations where the TPA will send a letter to the employer and say, this happened, but this is not a breach that must be disclosed. It's not the TPA's call, it's the
Right.
employer's call. And I have not always agreed with their assessment as to whether we need to provide a notice under HIPAA. So
And
that's
I've
really
I've been
key.
in I've been in the same place, and there's sometimes where I will overrule. Actually, I'll say, no, I don't
Yeah.
think this calls for breach notification at all, but it does demand an objective review, and you don't just hand it off to the business associate to decide.
So we're talking about electronic PHI. There are also the HIPAA security rule. There's the HIPAA privacy rule and HIPAA security rule, which addresses electronic PHI and the need for a health risk or an assessment of a risk analysis of whether the electronic PHI is protected. There's some kind of unexpected advantages to going through that process with the HIPAA security rule.
Yeah, I actually think there are, and I've recommended non-healthcare entities take a look at the security role risk assessment. So it's one of these things that there's a perception that HIPAA requires all these particular details as it relates to security. And the reality is that the security role risk assessment for HIPAA has essentially been unchanged since 2003. Okay, so that predates every smartphone on Earth, right?
Right.
And you wonder, how is it possible that that could still be an applicable security rule? And the answer is they really did a good job of designing it to be sort of broad categories. And then within those categories, there's a lot of flexibility. It's actually built into the process as this notion of flexibility. And it doesn't matter what kind of information you're dealing with. If you can go through the risk assessment and feel satisfied that you've got good security in place, whether it's a HIPAA rule or anybody else, it's just a solid template for going through security. So
Yeah, that's a good
it's
point.
a rare occasion for me to be complimenting any federal guidance, but that's the one exception. I
Yeah.
think, yeah, it's a pretty good tool.
And what I've found is going through the HIPAA security rule, the employer already has these security procedures in place. Like
Exactly.
we don't have to create them. If we had to create them, there's a problem with their overall security. It's just identifying, yes, we meet the HIPAA requirement because we do this in our
Exactly.
regular security policy.
Exactly. So the way that I like to describe it is that most, I mean, 99% of the things in the security risk assessment, any responsible current operator in the digital world is going to satisfy.
Yeah.
What you don't want to do is just go through and just check the box and say, yes, we do that. What you want to do is instead create the roadmap and say, when it comes to this category, yes, here's who's in charge, here's where we store that all. And so God forbid you had an OCR investigation and they say, let's see your HIPAA risk assessment. You could literally hand them the risk assessment and go off to lunch and come back and they'd be able to follow everything as opposed to having to be guided through the document. So that's the way that I recommend, if it's obviously directly applicable to the plan, to handle those risk assessments. But again, I think a lot of organizations could learn a lot from the HIPAA risk assessment.
So Nathan, do you have any like a simple high level rule that employers can apply to ensure compliance?
Yeah, it's real simple. Stay in your lane.
Yeah.
If you have health information, use the health information for the job function that you have. Don't share it and don't go looking for other health information that is outside of your lane. If you if you have people that stay in their lane with respect to health information, they will be 95% of the time in compliance with HIPAA. It's really not that hard of a rule. There's a lot of nuance, but just stay in your lane and you're almost all the way there.
That's great advice. Do you have any other words of wisdom as we end the podcast?
Yeah, just whoever you are, whatever kind of covered entity you are, and frankly, any kind of organization, be careful with your insurance. It is so easy with respect to cyber insurance, which is kind of an evolving topic anyway. It's so easy to think that you're well covered and not be. And so we deal with this all the time when we've got clients who've got data breaches. Sometimes we'll have a client that really wants to work with us at Williams Mullen, as well they should, because we love what we do and we're good at it. But they discovered that their insurance doesn't allow them to have the benefit of working with us. They got to work with some unknown panel counsel. Those are things you can negotiate up front when you're getting insurance. So you don't want to be in the breach scenario and discovering you don't have the insurance that you really want. So I don't live in the insurance world, but I don't think the premiums are that different from getting better coverage, but it's just so easy to just check that box. And I've seen a lot of frustrated clients along those lines.
Well, Nathan, thank you so much for being on the podcast. I think this is really great guidance for
Well,
our
thanks for
clients.
having me. A lot of fun.
That'll wrap up this episode of the Benefits Companion. If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamswellen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.
This podcast contains general condensed summaries of actual legal matters, statutes, and opinions for information purposes. It is not meant to be and should not be construed as legal advice. Individuals with particular needs on specific issues should retain our services or the services of other competent counsel.